Hey guys, it's Brad from GeorgiaProbateResource.com and Arbor Properties. Thanks for checking out another one of our videos here. It's a beautiful day outside. It's fall. I love sitting outside this time of year. So I'm going to make the video outside here. I'm sitting out beside my house. And oh, by the way, this particular house right here was a probate inheritance deal once upon a time. This is actually my next door neighbor's house, but we bought this house and flipped it last spring. Did a full rehab on that house. And then sold it, and then we built a house right next to it. So I split the lot up, and then we built a new house next to it. So we've got a great neighbor that lives there now, and then we live right next door. So this was an inheritance deal, a probate deal, and we were able to purchase this from the heirs. There were 3 heirs, and fortunately, one of the heirs, she works for an attorney, so she was able to get everything squared away. But anyways. So I want to talk about the process and the paperwork that you might need in order to sell a house in probate. So there's a few different situations here. You've inherited a house. Depending on the amount of time it has been since you inherited the house, and whether or not there was a valid will. If there was a valid will in place, that's what the courts refer to as the person died testate, which means with a will. In which case, there is usually an executor or multiple executors. Most cases, it's just one executor named in the will. And that person is in charge of the estate. They're in charge of, dealing with all of the things. They're going to deal with the courts. They're going to file all the paperwork. They're going to do all the stuff, right? They're the person that was appointed by the person who passed away to be in charge of the estate. So in order to be able to sell a piece of real estate, or really any of the assets in the estate, you're going to need Letters Testamentary. So that is a document you get from the court, and I'm referring to Georgia probate rules here. So you're going to get Letters Testamentary if there's a will. And once you get those Letters Testamentary, that is basically the court validating that you as the executor have authority to deal with the assets according to what the will says, okay? So let's go to the other side of the coin here. The other side of the coin is there was no will, or the will was deemed to be not valid, in which case you are going to have to file for letters of administration. So you're going to petition for letters of administration with the courts, and those letters of administration are just like the Letters Testamentary, are going to give you the authority to sell assets and distribute assets on behalf of the estate. The difference between these two scenarios is when there's a will, the will usually spells out how those assets are to be distributed amongst the heirs. When there's an administrator situation, you and the heirs, you might be one of the heirs, you might not, it just depends, have to decide how the assets are going to be split up. And if you can't come to an agreement as to how those assets are to be split up, the courts are going to decide that to you. And let me give you a little tip here. I've been doing this for a long time. We've done a lot of deals. And again, I want to preface this with, I'm not an attorney. I don't claim to be an attorney. We just do a lot. We purchase a lot of houses in probate. So we've been down this road a million times. If you need a great attorney to talk to, we have a great network of probate attorneys, and we'd love to get in touch with one of them. We've sort of worked with a lot of them throughout the Georgia area, and we can get you in touch with one in your local area that can help you out and best solve your case. So, but what I want to say is it would be in your best interest as heirs of the estate to come to an agreement and get it in writing as to how the assets of the estate are to be distributed. Because if you can't do it, the court is going to decide that for you, and they're probably just going to split it up evenly down the middle. And if you let the court decide that, your probate case is going to take a lot longer to resolve, because then you have to go through the process where everyone has to be notified, everyone has to sign off on these documents. You're going through a document charade if you do that. So it would be in your best interest to do this ahead of time to determine how these assets, a lot of times it's just a house. And maybe there's 3 heirs and you split it 33, 33, 33, or whatever, right? But it would be in your best interest to figure that out ahead of time. So you, as the administrator, once everybody figures out how the assets are to be disseminated or distributed amongst the heirs, then once you get your letters of administration, typically your letters of administration are going to grant you what's called a leave to sell real estate or leave to sell real property. Once you have that document in your hand, you can close and sell the real estate. That doesn't mean the estate is closed out yet. That just means at that point in time, the court has granted you, the administrator, the authority to sell the assets in the estate. So there, the very next day, you could have that document. Heck, you could get it from the court that morning. We've even done this before, where literally the person has gone to the courthouse in the morning, gotten their signed letters of administration, brought it to the closing table. My attorney looked at it, validated that it is in fact correct and a valid document. And we have closed on the asset or the sale of the estate that afternoon. So they got the document in the morning. They went straight from the courthouse, drove to our closing attorney's office and sold us a house that very same day, or you can do it the next day or whenever. But you cannot sell that house until you have the letters of administration or the letters testamentary that details that you have the authority to sell that house. And that document is going to have a power granted in it that allows you to do that. There's another situation here, and this is an exception to the rule, but if the person has passed away many years ago, there are ways around probate, and I'm not going to get into the details about that because it's very, very unique situation to situation. But there are other alternatives if it's been, I believe that if it's been more than 3 years since the person has passed away, and then once it's 10 years is another milestone, there is a way to sell assets without the letters of administration or the letters testamentary, but it requires more hoops to jump through. It does not apply to every situation, so do not take this as a blanket statement that this applies in all cases, because it doesn't. You need to consult an attorney, and they will tell you whether that applies or not, in which case you might be able to sell the house with some additional paperwork and do that without going through the whole probate process. But again, that is an exception to the rule, and it doesn't apply in all cases. So do not think that this is a blanket statement, because I'm not making a blanket statement. So those are your situations. That's how you sell a house in probate, is you need to have those documents. If you do not have your letters of administration or your letters testamentary, you cannot close and sell the house until you get that document. Because the closing attorney who handles that, in Georgia, we're an attorney state, a closing attorney is going to handle your closing. They're going to need that document in their file in order for their title underwriters to approve title insurance and allow you to sell the house. And don't ever let someone tell you that you can quit claim deed it over. Don't do quit claim deeds. Do not do quit claim deeds. Now, there's an exception where certain heirs might quit claim interests away, but still the person in charge of the estate has to do. When we purchase houses, we need a warranty deed. That means there's title insurance. That means an attorney has reviewed it and they have deemed this transaction to be a valid real estate transaction, that all the ducks are in a row and everything meets Georgia law in accordance to be able to sell this house. So I don't want to go too long here. We're 8 minutes into this. I hope that helps. We'll do a lot more videos. If you have a house that you need to sell that you've inherited, we are the inheritance probates experts in Georgia. We have done tons and tons and tons and tons of deals over the years. We're very experienced in this, and we work with a network of real estate or probate attorneys throughout the state, and real estate attorneys that can help you sell these assets and these houses. We've been through this rodeo a million times. Our team is extremely experienced in this. We understand how to deal with the family and the family dynamics, because there's a lot of family dynamics involved in this. This is not just a cut and dry house sale like a normal house sale. These are very unique, and we are equipped as a company to handle that and very experienced. So you can call us at 770-810-5715, or you can click on the link below in the description. It will take you to a website. You can fill out the form on our website, and a member of our team will call you as soon as possible. So thanks again, guys. Have a great day. Talk to you later.